The email was sent this morning by Allison Bailey.
Okay. I haven't received any notification. Mr. Whitten, I'm not sure if perhaps if it's possible for you to give him a little a call or a notification, and we'll see if just to make sure that he's received the link.
Okay. I will. Thank you.
Thank you.
I just made a follow up on my end for the elder.
Natasha, it's Allison here. I did send the link.
Perfect, thank you.
I will resend it.
Mr. Frater, this will not eat into your allotted time as indicated in your schedule, so we just may finish a little bit later.
Thank you, Justice.
I confirm that Allison did resend the link for Mr. Sapani for the elder.
It's giving me an opportunity to quadruple check to make sure I've got everything on the screen before me. So.
Mr. Nawagabo, do you have any update on Mr. Elder Sakani?
No, we haven't heard yet. We
We have our office checking in right now with him, but they can't get a hold of him either. So I would suggest we just get started.
Yes. Mr. Justice Ramal.
Perhaps funny if I might suggest Justice Fable and the parties that when we are able to reach the elder, that we maybe take a break in the proceedings and to allow for the ceremony.
Let's just do a quick roundtable, starting with the applicant. Primarily the applicant. It's the applicant's time, I guess. Mr. Frater, what's your position on that?
Well, Justice, I know this is important to the AFN. My preference would be not to be interrupted. So if the court wanted to take a few minutes now to let the AFN try and track the elder down, I'm completely comfortable with that.
Yes, I think I would prefer as well if we started that way with the elders' involvement, and then that would just give us an opportunity just to roll along in light of his or her words. I can't remember if male or female elder, but so let's
Justice Fable, if I may, I wasn't suggesting that we would interrupt anybody's submissions. I thought that if we were able to reach him and immediately after lunch break or something, or after one of the morning or afternoon breaks, we could allow the elder to make his ceremony.
Mr. Frater, that seems like a reasonable approach. What are your thoughts? So something a little bit later, maybe after our break.
Yes, I'm fine either way. If they want a few minutes to try and contact them, I'm happy to stand down.
Sure. Okay. Well, we've got a combination of approaches. Let's give another 5 minutes to try and contact. Thereafter, we will just let them know. I know it's if we're inviting an elder to begin our proceedings or to say some words before our proceedings, just to have some effort and for the elder to join and have to wait doesn't seem. If we have to do that, we'll do that. But 5 minutes, if we could just give that time to try and locate and contact. Let's try it that way, and we'll do the option B thereafter. So we could probably turn our cameras off and then we'll reconvene. It's 9:45 basically, so Eastern. So in 5 minutes. See you all again very soon.
Well noted.
Recording stopped.
Hi again, Mr. Justice Favel. We haven't received any update if the elder has joined. I may suggest maybe during lunch or recess if the elder join in. Up to you, sir.
Yes, I think under the circumstances, this is one of the unfortunate consequences of the pandemic and technology. Yeah, I'll extend my apologies in advance to the elder, and we'll begin, and then we'll have the elder secured for immediately after our lunch break if the elder is available. So my apologies in advance.
Thank you. I will restart the recording and I will open up court.
Recording in progress.
Please be advised that this hearing is being recorded. The special sitting of the Federal Court at Ottawa by Zoom webinar video conference is now open. Presiding the Honorable Mr. Justice Favel, before the court filed T-1621-19 and T-1559-20, Attorney General of Canada against First Nation Child and Family Caring Society of Canada, Assembly of First Nations, Canadian Human Rights Commission, Chiefs of Ontario, Amnesty International, and Anishinaabe Nation. Appearing for the applicant, Robert Frater, Max Beanie, and Meg Jones. Appearing for the respondent, First Nation Child Family Caring Society of Canada, David Taylor, Sarah Clark, Anne Levesque, David Wilson. Appearing for the respondent, Assembly First Nation, David Nawagabo, Stuart Woodkey, Adam Williamson. Appearing for the respondent, Canadian Human Rights, Brian Smith, Jessica Walsh. Appearing for the respondent, Chiefs of Ontario, Maggie Wente, Joel Morales, Sarah Zuloff. Appearing for the respondent, Congress of Aboriginal People, Andrew Loken. Appearing for the respondent, Amnesty International, Stephen Elward, Justin Safayeni. Appearing for the respondent, Anishinaabe Oski Nation, Julian Falconer, Akosua Matthews, and Molly Churchill. Thank you, everyone.
Good morning, everyone. And thank you for the registry for trying to accommodate everybody. And so far, I think everybody's connected. So that's a good start. As I mentioned, I think with the unfortunate inability of the elder to join us at the opening, it's just a consequence of this IT issues and which sometimes occur as a result of these types of hearings. So we're gathered here in this manner. The last time we were together, we were in person. So it would have been nice for all of us to be in the same room. I'm going to provide a brief overview of this week's proceedings and introduce the parties. As the registrar has indicated with the list of the parties, this case is very much a complicated case, a fulsome case involving lots of evidence and many parties. So this week's proceedings, and well, before I begin, I'm going to try and summarize things. And I know with any kind of summary, you can either be too brief or take too much time. So I'm opting for option one, which is a brief overview, and I use that term very applicably. It's brief. So this week's proceedings are part of a long-standing series of proceedings, both before the Canadian Human Rights Tribunal, or the tribunal as everybody's referring to it, and this court concerning Canada's funding for First Nations Child and Family Services, as well as for Jordan's Principle. A very brief summary or the conclusion. In 2016, the tribunal found that Canada's First Nations Child and Family Services program and its approach to Jordan's Principle was discriminatory. That decision will be referred to by the parties and the court as the merits decision. I think everybody's using the same term when it comes to that particular decision. Today, we will begin hearing submissions from the Attorney General of Canada on behalf of the Government of Canada, who seeks to judicially review two decisions of the tribunal, which were arrived at after the merits decision. And again, just to summarize, the first decision is what's I'll refer to as the compensation decision, relating to compensation awarded to removed children and their caregivers. And that is the subject of Federal Court File T-1621-19. There were also a series of tribunal orders related to this decision, the compensation decision, which the parties will undoubtedly discuss in their submissions. The second decision, the First Nations Child Definition decision, relates to Jordan's Principle, and that is the subject of Federal Court File T-1559-20. There is an additional tribunal order related to this, which the parties will also discuss in their submissions. Both of these decisions or orders of the tribunal are lengthy, but the parties' written submissions and their oral submissions will address the specifics of these decisions in their respective arguments and submissions. Before this court, Canada is the applicant seeking judicial review of both the compensation decision and the First Nations Child Definition decision. The Attorney General of Canada, representing Canada, has made written submissions and will be making oral submissions as well. The respondents, as the registrar has pointed out, are the First Nations Child and Family Caring Society of Canada, referred to, I think, by consensus as the Caring Society, the Assembly of First Nations, the AFN, the Canadian Human Rights Commission, or the Commission, the Chiefs of Ontario, Amnesty International, and the Anishinaabe Nation. The respondents have also made written submissions and will be making oral submissions. The Congress of Aboriginal Peoples is an intervener in only the First Nations Child Definition decision, and their participation is limited to their written submissions respecting that decision. On judicial review, the role of the court is not to reweigh or reassess the evidence or to redecide the case. The parties are in their submissions, as we'll soon hear, have made submissions on the standard of review that the court should employ concerning decisions of this nature. So we'll hear those submissions as well. Council have agreed with a general timetable of submissions, and they have agreed that the majority of this week's time is devoted to the compensation decision. Once submissions cease concerning that decision on Thursday, the court will begin hearing submissions on the First Nations Child Definition decision. Those submissions will continue until the end of the day on Friday. And so right now it's 10:05, and I understand, as we discussed, when we have a break and we reconvene after the break, the lunch break, we will hopefully have the elder connected, and we will begin the afternoon's proceedings with the elder's words.
May I interrupt?
I think perfect timing. I believe we have the elder who joined us.
I was just going to say we're able to contact the elder, sir.
Okay, well that's perfect. Perfect timing. It's best to have this at the beginning of our proceedings. So without further delay, I'll turn it over to Elder Sakani for some opening words.
First, I apologize because I had all kinds of technical difficulties. It must be that COVID thing. interfering because it's really becoming difficult for us to push back that virus. Anama manchur ajapichdito uto Ninan Mushkigo. It's coming to our land, ancestral land area in full force. My community at one point last week had 69, but this week we dropped down to 23. So we started doing what was asked from us, but our neighboring community, which is about 7 miles from us, Cash, have over 250. And it's mostly children. So it is kind of worrisome because of the fact we just don't have the medical facilities and personnel to quickly respond like they do in the South. But I also understand that the Army is going to be coming into Saskatchewan First Nation and helping out. So it's been hard. I mean, especially with children now, because the youngest one to get a variant is 7 or 8 months old. So I apologize for being late. Matiga Nikiskaw no town Kishamantu. Anna Katipejagate Miswebabo. Kahujitak Miswebabo. Omau Taskivano Nagawianan. I just like to acknowledge the great Creator for guiding me, for helping us, and also to just help us in prayer as we begin this important session. And also for giving us all things on Mother Earth so we can live as people. Kinoa miswebugotayegote nagachehitas anama kanushataye. I also ask that each of you here in this room, please look after yourselves, take care of yourself, because of the importance of what you're going to be talking about this morning. I also ask that each of you speak with your hearts. In your mind, your head will guide you in coming up with solutions that is going to, that's going to help all people involved. Ogamaganesta, Ginawa, Imitigate, Nigaskato, the Gumoshama, Gogokama, and the Tekitayek. I also ask you guys, all of you folks, to pray, to acknowledge the spiritual grannies, the spiritual grandpas of your ancestral land. Come in and help us. Ogamaganesta, Misuebugo, Kayamichiguta, to every one of you that are here that come to speak, I ask you get that help. Ogamaganesta, Nichenino, Misuebugo, and also to all my people that are going to be affected of what we talk about today, will get the help that we're all trying to strive for. Ogamaganesta, Nitin Wakatatik, Ikamanek, Gatonawa, Nagachihitizuk, Anigaraz Gakazichik, Wichina. And also to all my people across Turtle Island, the ones that are ill with this virus, that they get help. But not only my people, Misawebo Gatachaguta Canada Tonoa, to all the people that live in this country called Canada. Wichahina Tamagona. Ajagitan Gaimichigan, and Gayamian, Ogamaganesta Kinoa. I finished my prayer of greetings, and I thank you folks for being patient with me and I ask that you all speak in a good way. So what we're going to have today, the end result is we're going to have something good come out of our sessions. And Judge Gatono. And I also pray for the person presiding over the judge. May we help them come up with a good decision that will serve all people. Thank you, folks.
Thank you, Elder Sakani. Thank you for those good words. I think you've set the context for today's proceedings. So again, thank you very much. I will turn it, I think with that, I provided the introduction, and I think we're ready to begin with Mr. Frater. And I haven't lost sight of the time, Mr. Frater, so we will make sure you're, based on the timetable that you provided, that you are allotted the same amount of time as what the parties have agreed upon. So, Mr. Frater, the floor is yours.
So, thank you, Justice, and I hope I'm not going to use all of that allotted time if it's reassurance to anyone. Justice, I acknowledge that I am speaking to you today from the traditional territory of the Algonquins, and I also wish to thank the elders for sharing his wise words with us this morning. Justice, the need to reform Canada's policies and programs concerning child welfare, which inspired the complaint to the Human Rights Commission in this case, has been rendered all the more urgent and poignant by the heartbreaking news of the recent discovery in Kamloops, British Columbia. All Canadians mourn the loss of those children and must support the families, communities, and residential school survivors who have had their suffering intensified by this terrible news. We grieve as one. Canada has acknowledged the need to reform its child welfare policies and programs, and to recognize the fact that the old policies and programs caused harm. Canada has also recognized a need to compensate the children affected. But the need to acknowledge past harms, to redress the wrongs, to prevent them from happening again, does not justify the orders at issue in these judicial reviews. In both of these judicial reviews, we will be trying to demonstrate that the decisions at issue reach unreasonable outcomes through an unreasonable chain of reasoning. Now, the Supreme Court's decision in Vavilov tells us that the reviewing court must be concerned with the reasonableness of both a decision's reasoning process and its outcome. Justice, for the purposes of my submissions, I'd ask you to have access to our condensed book, the 2 volumes of it, whether electronically or in hard copy, but I will be referring to them this morning. And at tab 1 of volume 1, we have provided the relevant passages from Vavilov. Paragraph 86 is the support for what I just said to you about the fact that the Supreme Court has emphasized that reasonableness applies both to the reasoning process and to the outcomes. Now, we say that the compensation decision reaches unreasonable outcomes through an unreasonable reasoning process. Why are those outcomes unreasonable? Among other reasons. First, the decision fails to differentiate between the experiences of children. According to this decision, a child who is removed and spends 3 quiet days with a family friend outside of the community receives the same compensation as one who spends 13 years shuttling between foster homes and experiencing abuse. A girl whose parents reluctantly surrender her just so that she can get the services she needs gets the same compensation as the boy who did not get an education tutor as quickly as the tribunal thinks he ought to have. Second, the compensation decision lacks any sense of proportion. The child who did not get their tutor quickly gets the statutory maximum compensation of $40,000, as do each of the child's parents. Every removed child, whether removal was necessary for their protection or not, gets $40,000, as does each parent unless they were found to be abusers. The third point I would make at the outset is that this decision fails to acknowledge the complexity of the removal issue. According to the tribunal, Canada's underfunding of child welfare services is essentially responsible for all harms, even though the complainant's own evidence demonstrated that the reasons for removal may be complex and multifaceted. Why is the reasoning process unreasonable? We say that, among other things, first, the tribunal failed to limit itself to the complaint before it. The complaint before it was directed at the discriminatory underfunding of child welfare services for First Nations children on reserve. Compensation decision was inconsistent with the nature of the complaint, the particulars to that complaint, and the evidence, and thus exceeded the tribunal's limited statutory jurisdiction. Second, the evidence does not support the sweeping orders made in this decision. When a decision maker lacks evidence, the shortfall cannot be made up through a presumption of facts, borrowing facts from reports made by other bodies based on other evidence, borrowing facts from reported cases based on the records before those courts, or generalizing from any of those sources. There are many examples of irrationality in the tribunal's reasoning process. Seriously flawed reasoning led to unreasonable outcomes. Let's look in greater depth at this decision. Now, our argument is that this decision suffers from a variety of defects that Vavilov identifies as hallmarks of unreasonableness. Tab 1 of our condensed book, you will find many of the key passages from Vavilov that must guide your review. As I said in my opening words, our challenge to this decision is not simply about the outcome. It is about the reasoning process that takes us there. And Vavilov says that both must be reasonable. Now, there are 7 parts to the argument that I intend to put to you this morning to indicate why, in our view, the compensation decision is unreasonable and should be set aside. First point I will make is that the tribunals failed to focus on the complaint before it. Second, there was an absence of evidence to support this decision. Third, the tribunal failed to apply principles such as causality and proportionality, which are critical to determining just remedies. Fourth, tribunal intruded on this court's jurisdiction. Fifth, there was an absence of a legal basis for the finding of willful and reckless discrimination. Sixth, there was procedural unfairness in the finding that discrimination is ongoing. Seventh, the absence of a factual basis for the Jordan's Principle Award. And finally, I will address the order that we seek. So let's look at those 7 types of failings in this decision. Now, this case in our submission involves jurisdictional error. In the context of this case, jurisdictional error is simply a shorthand way of expressing the idea that a decision maker lacked the authority to make the decision at issue. That can happen in many ways. Cases where jurisdictional error are found usually lead to a common result. The decision must be set aside because it is unreasonable. Here, the problem is that the tribunal had a narrow statutory jurisdiction to consider complaints involving discrimination. Tab 3, we've given you, Justice, the relevant parts of the Canadian Human Rights Act. And I'm not going to take you to it at length. The one that's relevant for this part of my submission is that Section 50 sub 1 of the Act is key. It gives the tribunal the authority to inquire into the complaint, i.e., the complaint that has been referred to the tribunal by the Commission. It's also important in my submission at the outset to bear in mind the words of the Supreme Court in its decision in Moore. And you'll find the relevant excerpts from Moore at tab 4 of our authorities. And I'll take you to that because I want to take you to one particular paragraph of Moore decision, and that's at paragraph 68. The Supreme Court tells us something important about jurisdiction. The tribunal, this Moore is a human rights case, the tribunal only has jurisdiction to give a remedy in relation to the complaint as framed by the complainant. Those are the words that the Supreme Court used in paragraph 68. We have highlighted those at tab 4 to emphasize, because it's a point I'm going to come back to repeatedly. So while the tribunal may have relatively broad powers to receive evidence, as pointed out by the Commission and others in their submissions, it has to exercise those powers in relation to the complaint as framed by the complainants, and must base its decision on the evidence presented. Otherwise, it is unreasonable because the tribunal is doing something it has no authority to do. Now, the tribunal's own rules reinforce this point. At tab 3, we've given you a rule or section 6.1, 6 sub 1 of the tribunal's rules. And if you can briefly turn that up, Justice, it's at the end of what we've given you at tab 3. And what's important are 6.1a, b, and c, because what the rules tell us is that a complainant must provide a statement of particulars that sets out the material facts, the position on the evidence, and the relief sought. All of those things are fundamental to a fair hearing. They allow a respondent to know the case it has to meet. So what was the complaint here? What was the case that Canada had to meet? The complaint, the particulars, and the evidence called by the complainants are consistent here. They lay out a case alleging discriminatory underfunding of child welfare services for First Nations children on reserve. Let's look at those documents because we've provided them to you at tab 2 of our condensed book in volume 1. And the first document you'll find there is the complaint filed by the AFN and the Caring Society. The complaint initiated those proceedings. Let's have a brief look at that. It's a long document. I'm not going to read it to you. I'm not going to read any lengthy documents to you today, Justice. But this one is important, and we've highlighted in the condensed book key passages. But let me just read to you the first sentence and the last paragraph. In the first sentence under summary of the complaint, it says, on behalf of the Assembly of First Nations and the First Nations Child and Family Caring Society of Canada, we are writing to file a complaint pursuant to the Human Rights Acts regarding the inequitable levels of child welfare funding provided to First Nations children and families on reserve pursuant to the Indian and Northern Affairs Canada funding formula for First Nations Child and Family Services, known as Directive 20-1. You flip over the page to the end of the complaint. It ends where it begins. We allege that Directive 21 is in contravention of Article 3 of the Human Rights Act, in that registered First Nations children and families resident on reserve are provided with inequitable levels of child welfare services because of their race and national ethnic origin as compared to non-Aboriginal children. The discrimination is systemic and ongoing. Clearly, in our submission, this was a case about systemic underfunding. In the complaint, we've also highlighted for you the spare references made to Jordan's principle. Our point there is simply that the references are few, a point I will return to. Now let's look briefly at the particulars as well. Not only the complainants, but the commissions and our own. So we've got those at the sub-tabs for you. And at tab 2A, you have the Caring Society's particular. And in the overview, we've highlighted for you the first 4 paragraphs, which are all about the insufficient funding that was at the center of this complaint. I'd highlight as well for you paragraph 17. Let me read that one to you. The complainants submit that they have established a prima facie case of discrimination on the grounds of race or national or ethnic origin. Only First Nations children and First Nation families on reserve suffer the effects of the discriminatory practices. At tab B, you'll see the particulars of the commission. And I'd emphasize in particular to you in the commission's particulars, paragraphs 10, 12, 14, and 17. In particular, those paragraphs identify this case as the commission understood it. And the commission understood this case from its particulars as a case about insufficient funding. Very clear in their particulars. The other particulars I've given you are our own at tab C. I'm not going to read those to you, but it shows that Canada understood the case in the same way. Now, we argued before the tribunal that this was not a case for individual compensation because of the complaint and the particulars. And in my respectful submission, the tribunal provided unconvincing answers to our position that they were considering a remedy, individual compensation, that was inconsistent with the complaint as framed by the complainants. Their first response was to say that the complaint is not to be treated as a criminal law indictment. They said that at paragraph 100 of their decision. And we say, while that may be true, the complaint has to mean something. A respondent plans its defense accordingly. That is how litigation must be conducted. It is a simple question of fairness to the opposing party. Tribunal's second response was to say that in human rights cases, particulars are more important than the complaint. You said that at paragraph 102. Problem with that reasoning is that, as we showed you, their own rules demand rigor, and the particulars provided by the complainants here do not justify the orders made in the compensation decision. Emphasizing the importance of particulars is no justification for this decision. Vavilov tells us that reasons must justify decisions. And this is the point I'm going to come to repeatedly. So let's just look at the paragraph from Vavilov that says that. It's at tab 1.
Mr. Frater, before
Yes.
you leave that, just in relation to what the point you just made, paragraph 101 of the compensation decision sets out, just to paraphrase, I guess, that the tribunal must look beyond the complaint form to determine the nature of the complaint, and there's a reference to some case law. How do you, I want to just see your position in relation to that, that it's not, the complaint doesn't appear to be the be all end all. There's more.
Yes. I agree that that the complaint is not the be all and end all. The answer, the point that they made was expressed differently in another paragraph by saying, don't treat this as like a criminal law indictment that has to be proved in that way. It's something that initiates the proceedings. And it did. But my point is that the tribunal then says, don't put as much weight on the complaint as you do on the particulars. But the particulars are exactly consistent with the complaint in describing a case about systemic underfunding. And so, yes, it's true. It's not to be proved to the letter. But again, I say, if you give particulars and you particularize it in a particular way, that's what you prove, and that's what you get a remedy for. Otherwise, the litigation is unfair. So if I can take you back to Vavilov for a moment at tab 1. Paragraph 86 is the one that I rely on here. This is essentially the paragraph that says that the reasoning process must be reasonable and the outcomes must be reasonable. And what we've highlighted in that paragraph for you is the sentence that says, in short, it is not enough for the outcome of a decision to be justifiable. Where reasons for a decision are required, the decision must also be justified by way of those reasons by the decision maker to those to whom the decision applies. That's a basic proposition of fairness to parties. So I want to go back again to the particulars again, to look at the nature of the claim that was made and the remedy that was sought. So if we go back to the Caring Society's particulars at 2A, in respect of compensation, here is what's sought. It's at paragraph 21 sub 3. What they say is, pursuant to the sections of the Act, requiring compensation and special compensation in the form of payment of $112 million into a trust fund to be administered by the Caring Society and to be used to, A, as compensation, subject to the limits provided for in sections 53.3, for each First Nations person who was removed from his or her home since 1989 and thereby experienced pain and suffering. B, as compensation for the expenses required to enable those persons who experience pain and suffering to receive therapeutic, repatriation, cultural, and linguistic services, and for the expenses to enable First Nations Child Family Service agencies to provide such services. So what you see there in my respectful submission is the request is for a payment of $112 million into a trust fund. I just paused there. 112 million, we know from the complaint, was the alleged annual shortfall in funding. To the extent individuals are to receive compensation, it's only for children removed from their homes and not paid to children directly, but to a trust fund, so that those who experience pain and suffering and needed services may receive those services. There is no request of any sort for payments to parents and grandparents, as later ordered in this compensation decision. No compensation is requested for failure to comply with Jordan's principle. The primary remedies sought and the remedies they obtained in the merits decision and others was funding reform. In 2018, the tribunal's exercise of remedial jurisdiction went so far as to require the government to fully reimburse agencies, i.e., to pay the actual costs of delivering the services. As we have described in our factum at paragraph 44, the government has spent billions on reform measures in answer to the complaint as framed by the complainants and to address the discrimination identified by the tribunal in its merits decision. Now, the tribunal's third answer to our argument that they were changing the nature of the case at the remedial phase was to mischaracterize our argument. First, they said that our argument was that individual remedies cannot be given in cases of systemic discrimination. They said that at paragraph 131 of their decision. That was not and is not our position. Clearly, the remedial provisions of the Act do not prevent that from occurring. Our position is that it should not occur where the complaint, as framed by the complainants, and the evidence that they led, is solely focused on systemic underfunding. And we are not claiming, as both the Caring Society and the AFN erroneously attribute to us, that systemic discrimination does not cause individual harm. No one would bring a case of systemic discrimination if it did not have harmful impacts. The issue is whether this claim, as framed by the complainants, justified the compensation order made. Now, the second major mischaracterization of our argument by the tribunal was to say that we were arguing that every child had to testify to warrant individual compensation. Tribunal said that would be traumatizing and absurd at paragraph 144. We agree, but that was not our argument. Our argument was that if you were going to ask for individual compensation, you had to frame the complaint that way. Either you had to at least have a representative victim or allege a group of victims and follow it up with evidence. It's not that every child had to testify. It is that the tribunal did not hear from any, nor did they hear in any way from parents or grandparents who also received the maximum awards for pain and suffering. Now, the tribunal's responses to our positions in our submission are simply fallacious. They're straw man attempts to characterize our argument as something other than what it was. To justify its approach, the tribunal relied on the famous pay equity decision in Walden. We've given you excerpts of the Walden case at tab 5. But in that case, Justice, there were 417 individual complainants. There was also a union as a party to represent the group. Individuals were compensated, but several of the individual complainants testified. There was an extensive record and discussion, both before the tribunal and on judicial review, of how individual damages should be assessed and calculated. This case, the case before you, was nothing like Walden. No individuals, no representative individuals, no groups, no one with authority to act for individuals. Now, the AFN says a resolution of chiefs authorized them to ask for compensation for individuals, but they cannot be considered as acting for the children in the way class counsel in this court do in class actions. On the other hand, AFN's counsel is class counsel in this court for individual children in the class action that has been filed, where they do represent clearly those interests. In this case, there is also no evidence led for the purpose of demonstrating the pain and suffering of children. No evidence was led about the experiences of their parents or caregiving grandparents. And in respect of Jordan's principle, no compensation at all is asked for in the complaint as framed by the complainants, much less leading evidence to show the nature of the pain and suffering they might have experienced. Justice, I believe you see my point. If you are going to frame your complaint as one of discriminatory underfunding, and the case and the evidence that you call is all related to that issue, your entitlement ought to a remedy is to a remedy that is responsive to the nature of the claim that of the case as you framed it. Indeed, we would say both the AFN and the Caring Society were well positioned to bring systemic complaints. Individuals should not have to bear that sort of burden. The complainants received responsive remedies in the way of very substantial systemic reform because of the merits decision and other tribunal decisions prior to this one. Those decisions, which my friends will be pointing you to as they have in their submissions, are all about responding to the complaint as framed. And while it was giving those remedies, the tribunal also repeatedly recognized the true nature of the complaint as framed by the complainants. If you go to tab 6, Justice, what we've given you there.
Mr. Frater, just before we go there, I know I can't pinpoint exactly where the reference in one of the respondents' written submissions were. There's a lot of information, but there's a reference to I believe it was in the AFN submissions. There's a reference to various individuals, and I think the Caring Society does this as well. Individuals who were involved in the Child and Family Services program, who provided testimony or evidence of what they observed of the individual situations. And then when you look at the, I believe it's section 50 of the Act, the broad ability to consider things, so and I notice in your submissions or the AGC submissions, there's also a reference to little evidence. I don't think you said there was no. So are you just saying there's an insufficiency? Is that what you're
Yes, I'm going to deal with this point in just a few minutes when we go through the evidence. We're not going to say there's literally nothing, but the context in which that evidence was called and the purpose for which it was called matters. And we actually have done a bit of work to respond to the examples used by my friends. So if I can just take you back to tab 6 briefly, because our submission is that from the merits decision on up to this decision, the tribunal recognized the character of what it was dealing with, which was a complaint about systemic underfunding. If you look at tab 6 at paragraph 481, that is a reference to the merits decision. The next reference in 2016 CHRT 10, a few months after the merits decision, is to the same effect. It is about systemic discrimination. 2018 CHRT 4, we've highlighted for you paragraph 165. Let me just read that to you. As stated above, the CHRA's objectives under sections 2 and 53 are not only to eradicate discrimination, but also to prevent the practice from reoccurring. The panel finds that some of the same behaviors and patterns that led to systemic discrimination are still occurring. It has to intervene. This is the case here. And in that decision, they awarded a vast array of systemic remedies. Now, my friends respond to our argument about the shifting nature of their case by saying, essentially, we did ask for compensation, and in a general way, they are correct. I've already read to you paragraph 21.3, but what does that paragraph from their particulars tell us? We say it tells us 3 important things. First, that they wanted a fixed amount of money, $112 million, i.e., not the open-ended order that was ordered by this tribunal. Second, that it should be payable to a trust fund, i.e., no direct payments to the individuals, as was ordered by the tribunal. Third, that it would be used for 2 different purposes: compensation for pain and suffering and reimbursement for the giving and receiving of services, i.e., not the lump sum payment that was ordered by this tribunal. So let's go and look at the orders, because this judicial review focuses on those orders. And for that, I'd ask you to get out volume 2 of our condensed book, where we've included the entire compensation decision at tab 1. And where I want to start is at paragraph 245. So these are the tribunal's orders that were made, and these are the orders that we say are unreasonable. Paragraphs 245 to 257 are the key paragraphs, but 245, 249, and 250 are particularly important, as they define 3 distinct classes of children. Paragraph 245, and I'm going to come back to that paragraph a little bit later because it's a particularly important one. But paragraph 245 essentially sets out a class that will receive compensation of unnecessarily removed children, i.e., children removed for safety, usually because of neglect. And we're going to come back to the tribunal's use of the term unnecessary shortly. Second key paragraph sorry, I'll just pause. 247 is the one that gives the same compensation to parents and or caregiving grandparents. Paragraph 249 sets out the second class of recipients, and these are the necessarily removed children, i.e., children removed for their own protection, from abuse, say. And the third class is at 250. Those are the children who are to be compensated because they either did not receive services under Jordan's principle or experienced delay. Paragraph 251 extends that order as well to their parents or caregiving grandparents. Now, our submission to you, Justice, is that to the extent my friends are correct, that they asked for compensation, what they received from the tribunal are orders that are so different from what they asked for. They are not just hugely different in amount, but they are different in kind. Compensation decision provides no cap on the overall amount awarded, provides no limit on the numbers of children who can receive compensation. Compensation is awarded to parents and or caregiving grandparents, a class that was not part of the complaint. No compensation, much less individual or caregiver compensation, or willful and reckless compensation was asked for Jordan's principle. And the compensation is paid, according to the tribunal's order, directly to individuals who were not parties or represented in these proceedings. These are not just small differences. They are fundamental differences. Those particulars, which even the tribunal conceded were important, do not resemble this award. They do not reflect the complaint as framed by the complainants or the evidence they called in support. Our contention that this case does not justify the individual compensation orders made by the tribunal goes beyond pointing out the obvious limitations imposed on the tribunal by the complaint and the particulars. It is equally, if not more, about the evidence that was called and how it is inadequate as a basis for compensation. I want to turn to that evidence now. So our point about the evidence is really about the absence of evidence, because part of the tribunal's response to our argument is to say, in essence, well, we heard lots of evidence about individuals. They say this repeatedly in the judgment, but respectfully, repetition does not make it true. It requires demonstration. That is why Vavilov stresses that reasons must justify, particularly where the impact on the other party is serious. We say that this is not a case where the tribunal had the necessary evidence before it. This is a case where there was no evidence capable of supporting the sweeping orders that were made. Now, there are four ways I want to try and demonstrate the truth of that proposition to you. The first is by looking at the evidence the tribunal used to support its contention that the evidence was sufficient to support the orders made. The second is by looking at the other party's attempts to fill in the gaps in the tribunal's reasoning in respect of the evidence. The third is by looking at the tribunal's unreasonable use of evidence. And the fourth is by looking at how claims on behalf of parents or grandparents or Jordan's principal were simply not part of the complaint. So let's go to the first one. The evidence the tribunal says supports its decision. And as I said, repeatedly they ask you to go back and look at their other decisions, but they do attempt to justify the proposition that they had the evidence before them. And it fails to justify, as Vavilov requires. Its main recitation in respect of the essential evidence appears at paragraph 155 of the judgment. And at tab 7 of volume 1, we've reproduced those key passages for you. I'll just take you there briefly. You'll see at tab 7, at paragraph 155, the tribunal, this in our submission is their best effort at trying to justify the fact that they had sufficient evidence before them to make the orders that they do. It's a very lengthy paragraph. And I might just note about our condensed book. In most of the tabs, I have highlighted portions of either cases or their orders that I want you to look at. In this tab, at paragraph 155, all of the bolding comes from the tribunal itself. So presumably they think that's their best case on why they had enough evidence before them to make the orders that they do. And again, you have to read it as a whole, Justice, but our contention, the reason it's here, is for what it doesn't say. There is no evidence in any of what they say that shows that they had direct or indirect evidence of the harms experienced that would justify their reward. Instead, what they have are general statements of the kind that are responsive to the nature of the case before them, which was about systemic underfunding. And we say, despite the length of that, there is nothing there that justifies this decision. Now, we did not claim that the panel needed to hear from every child. The tribunal accused us of that at paragraph 188 of the judgment. Our point is that the tribunal didn't hear from any. Again, nothing in paragraph 155 begins to justify the sweeping orders that were made in this case. And that is exactly what Vavilov says a reasonable decision maker has to do. It has to justify its order. Now, my second point about the evidence is about the parties' attempts to fill in the gaps of the reasons. The failure of the tribunal to justify its order has led various of my friends to try and rehabilitate the reasoning by pointing to references to individuals that may have been mentioned in some context in the course of these lengthy proceedings. We deny that their attempts to justify are successful. But more importantly, Justice, Vavilov says you ought not to listen to them on that point. Let's go to tab 8, where we've given you another few paragraphs from Vavilov. The point of these paragraphs from Vavilov is to tell reviewing courts how they should deal with evidentiary issues. And so what you find in the first few paragraphs are some pretty conventional statements about the need to be deferential to decision makers. What I want to direct your attention to, Justice, is paragraph 97, which is at the bottom of the page. Let me read that to you. Indeed, Newfoundland Nurses is far from holding that a decision maker's grounds or rationale for a decision is irrelevant. It instead tells us that close attention must be paid to a decision maker's written reasons, and that they must be read holistically and contextually for the very purpose of understanding the basis on which a decision was made. We agree with the observations of Rennie J. in the Kamola case, where he says, Newfoundland Nurses is not an open invitation to the court to provide reasons that were not given, nor is it licensed to guess what findings might have been made or to speculate as to what the tribunal might have been thinking. This is particularly so where the reasons are silent on a critical issue. It is ironic that Newfoundland Nurses, a case which at its core is about deference and standard of review, is urged as authority for the supervisory court to do the task that the decision maker did not do, to supply the reasons that might have been given and make findings of fact that were not made. This is to turn the jurisprudence on its head. And in our respectful submission, that is what my friends are trying to do. The tribunal's reasons itself are insufficient to justify the orders made in respect of the proposition that there was sufficient evidence before them to justify the broad awards that they made. Now, even if you look at what they have done, I'd ask you to consider our response to what they have done, which you'll find at tab 9. And what we have done at tab 9 of the condensed book is to look at 3 parties' attempts to plug the gaps in the tribunal's decision on behalf of the tribunal. What we show in each case, we've created charts. It's very, it's long, but we've taken all of the points that they say shows that there was sufficient evidence before the tribunal, and try and show you what exactly that evidence was and in what context it was before them. So sometimes in our submission, what it amounts to is simply undocumented assertions that there was evidence, much as the tribunal did. Sometimes there's more substance to it. Now, what we're saying about all the evidence that my friends point to is not that it is valueless. But what you will see if you read it is that the evidence was called and has value in demonstrating why their claim of systemic underfunding should be accepted. That not only was the funding inadequate, but that it had adverse impacts in a general way. The evidence was directed at that issue and succeeded in persuading the tribunal. Canada accepted the result of the merits decision and started reform of the system. So we say that to the extent the tribunal would have been aware of the experiences of any individual children, was it presented in a context of pursuing a finding of individual harms or as a remedy for individual compensation? We say not at all for the child beneficiaries of this decision, in our view. No evidence at all of the experiences of parents and grandparents of those children, all of whom received the maximum $40,000 unless they were abusers. Not at all for the purpose of demonstrating willful and reckless discrimination, which effectively doubled all the awards the tribunal handed out. Now, my third point about the evidence is the tribunal's reference to other sources. The tribunal's reliance on reports or facts in reported cases to buttress its reasons does not create a record for compensation. There is no authority for the proposition that you can borrow facts to make out individual claims. And there is certainly no basis for the tribunal's claim at paragraph 210. And let me take you to that one. That requires you to turn up volume 2 again, tab 1, which is the compensation judgment. And I want to take you to paragraph 210. What the tribunal says at paragraph 210, if you have it, Justice, is in any event, even proof by presumption of facts, subject to being provided that such presumptions are sufficiently serious, precise, and concordant, applies to class actions, relying on a Quebec civil law case. More so in front of a human rights tribunal allowed to receive any type of evidence under the Act. With respect, Justice, there is no basis for a claim that they can rely on presumption of facts. That is an extraordinary statement and inconsistent with any fair litigation. Party has to be given a chance to contest facts. Now, the Wende report, upon which the tribunal places great weight, was itself a report about inequitable funding. Tab 11, we've given you an excerpt from the Wende report. And the Wende report was certainly useful on the question of whether funding was inequitable. And it was also useful on the question of how to fix it. But it does not, with respect, assist on individual compensation issues. Tribunal in our submission also uses an inappropriate way to fill in the evidentiary gaps. So at paragraph 126 of their judgment, which we've reproduced for you in volume 1 at tab 10, is an excerpt from another tribunal decision. And what they say there is that in a recent tribunal decision, Member Perot wrote about the pain and suffering award under section 53 sub 2. However, $20,000 is the maximum that may be awarded under the legislation, and it is usually awarded by the tribunal in more serious cases, i.e. when the scope and duration of the complainant's suffering from the discriminatory practice justifies the full amount. Good law, we agree. But the tribunal's use of it skips over the fact that there is no evidence before them of the scope and duration of suffering. I gave you in my opening remarks some hypothetical examples to show how radically different individual cases can be. If the tribunal had had evidence of the scope and duration of suffering, they surely would have differentiated cases in their compensation award, at least in some general way, by considering factors such as the length of time in care, the number of different placements a child had, or whether those children were subject to abuse. Tribunal did not do that because they could not do it. They did not have the record to do it. My final point about the evidence relates to the absence of evidence on the grandparent class and Jordan's principle. Now, let me take you.
Mr.
Yep.
Fraser, before you do that, if you could just, I'd like to hear your position or the Canada's position on paragraph 90 of Caring Society's 90 and 91 of their submissions. They talk about the harm in the nature of the removal as the harm, as opposed to maybe the details of harms that may have been suffered. That's how I read those two paragraphs anyway. But what's the position of Canada on the harm, as argued, seems to be the removal, just that in and of itself.
And I would say, with the greatest of respect to my friends, is they are attempting to fill in the reasons that the tribunal did not make. And with the greatest respect, that's not open to them. So if I can take you back to tab 10, to show you something else that the tribunal did in its reasoning to try and justify its award. So paragraphs 166 and 167 are interesting ones in our submission.
Sorry to interrupt. What tab are you referring to again?
Oh, sorry, I'm at tab 10 of volume 1.
Thank you.
And what I'm looking at tab 10 are the two paragraphs 166 and 167 of the tribunal's compensation decision. Okay. So what they do in these two paragraphs, both of them start with statements about the Supreme Court of Canada. The Supreme Court of Canada in 166 found that the removal of a child from a parent's custody affects the individual dignity of that parent. The start of 167, they do the same thing. They refer to a Supreme Court case. But the odd thing about these two paragraphs, so it leads you to the impression, by the way they start the paragraphs, that they are going to rely on propositions of law from the Supreme Court of Canada. And what actually appears in those decisions is something quite different. What it is, and it took a while, frankly, to figure this out, what they've done in those two paragraphs is to quote from the Wende report. And not just quoting from the Wende report, they're quoting from a particular part of the Wende report, which is about the possibility of using the charter to address the inequities of Canada's funding of child welfare. In essence, these are passages that come from the reports positing that there may be charter arguments that might support them. And it's presented here as justification for giving awards to the parent and grandparent class. And in my respectful submission, it is an attempt perhaps to use law to fill in the gaps of facts, but it isn't even a successful attempt. It's something quite different, where they've gone into a report that they rely on heavily and ignored the context in which the statements are made, which are essentially about positing the possibility of making a legal argument supported by the charter. That is not a way that's open to them to fill in evidentiary gaps. Panel then went on and asserted, we say without justification, that they had limited compensation to parents and grandparents, not other family members, based on the record before it. So what was it in the record that justified that decision? We don't know, because they don't tell us. They failed, we say, to justify their reasoning. Similarly, we say there was no evidence to support the Jordan's principal compensation order, but I'm going to deal with that separately in a few minutes. If I can then sum up on our position on the evidence. There was no evidence to support this massive compensation order. The tribunal's reasons attempt to conceal this basic problem by repeatedly and unreasonably stating that the evidence was there. Let's go back to Moore at tab 4, because Moore speaks to this as well. Tab 4 of volume 1, where we've given you parts of Moore. I want to read to you from paragraph 64, where it says, "But the remedy must flow from the claim. In this case, the claim was made on behalf of Jeffrey, i.e. Jeffrey Moore, and the evidence giving concrete support to the claim all centered on him. While the tribunal was certainly entitled to consider systemic evidence in order to determine whether Jeffrey had suffered discrimination, it was unnecessary for it to hold an extensive inquiry into the precise format of the provincial funding mechanism or the entire provincial administration of special education in order to determine whether Jeffrey was discriminated against. The tribunal, with great respect, is an adjudicator of the particular claim that is before it, not a royal commission." The Moore case is essentially the flip side of our case, in the sense that it was a case about individual compensation. The tribunal let in some evidence of systemic discrimination, but because it was relevant to the claim of individual compensation. In our case, it's the opposite. And what the Supreme Court did in Moore was to reject remedies that were systemic, because that was not the nature of the complaint before it. So we say the tribunal was certainly free to look at general evidence and anecdotal cases as to the harms or effects of underfunding in order to determine whether the funding of child and family services constituted discrimination. But the evidence giving concrete support to the claim all centered on the systemic underfunding. Individual compensation could not be reasonably viewed as a responsive remedy to the claim being made and the case that was actually brought. That makes the award of compensation unreasonable in our view. Now, Justice, I'm just about to move on to a different section, wondering whether this might be an appropriate time for a morning recess. I'm happy to keep going if you want, but
I think that's a good suggestion. I think we're going to be here for a full 5 days. That might be a good way to keep us all refreshed and attentive. So let's take 10 minutes, and we'll reconvene for. And just to make sure, Mr. Frater, that I'm following you, I think you just concluded on point 3, the unreasonable use of evidence. So I think you had a fourth point, and that's what you're going to be.
Yes, I'm going to move on to the fourth point. Okay.
I just wanted to make sure I was in the right state of your submissions. So it's 11:20 essentially. So at 11:30 we'll reconvene.
Perfect. Thank you, sir. This is well noted. The court is now in recess for 10 minutes. Thank you.
Recordings.
Good morning, Mr. Justice Favell. I just want to ask counsel if everyone is in agreement that CTV News be recording this hearing today. We had a request approved by the Chief Justice.
Yes. Well, if the Chief Justice has approved it, we're good with that.
We were asked to make sure that counsel were as well okay with that.
Yes. No problem from our point of view.
Thank you.
Good morning, Madam Registrar. That's fine with the Caring Society. Thank you.
Thank you.
Good afternoon. It's also fine with the Assembly of First Nations.
Thank you for confirming.
Fine with Chiefs of Ontario. Thank you.
And good afternoon. It's fine with Nishnawbe Nation. Thank you.
Thank you.
And fine for Amnesty International. Thank you.
And for the Congress of Aboriginal Peoples.
And I think that may just leave us at the Human Rights Commission. That's all fine. Thank you.
Thank you so much, counsel, everyone, for agreeing. I will follow up with CTV News. Thank you. The court is now resumed. I will hit the recording.
Recording in progress.
Okay, Mr. Frater, the floor is yours again.
Yes, thank you, Justice. And just to be clear about where I am in my submission, I just finished my fourth of 4 points about evidence, and now I'm turning to the fourth of 7 points that I'm making to you this morning. So the fourth point I want to make about the unreasonableness of this decision is the failure to apply relevant principles. Vavilov tells us that reasonable decisions have an internal rationality. This is the Supreme Court's way of telling us that decisions must be logical, they must be principled. An unreasonable decision does not have those qualities. It may be, in the words of the Supreme Court in Vavilov, based on unfounded generalizations. And let me take you to that paragraph briefly, because it is a brief paragraph at tab 1 of our authorities. And this, again, is a consistent theme that we say arises in this decision. Paragraph 104, what the Supreme Court said, similarly, the internal rationality of a decision may be called into question if the reasons exhibit clear logical fallacies, such as circular reason, false dilemmas, unfounded generalizations, or an absurd premise. And in my respectful submission, unfounded generalizations are something that appears in this judgment more than once. Let's look again at the order that was made under paragraph 245 of the compensation decision. So I need to take you back now to volume 2, to tab 1. Okay, and let me just do a bit of refreshing of your memory about that paragraph. Here's what it says. And I'm not going to read the whole thing, but the key part is the first part to it. The panel finds there is sufficient evidence and other information in this case to establish on a balance of probabilities that Canada's systemic racial discrimination found in the tribunal's decision merits decision and subsequent rulings resulted in harming First Nations children living on reserve and in the Yukon Territory who, as a result of poverty, lack of housing, or deemed appropriate housing, neglect, and substance abuse, were unnecessarily apprehended and placed in care outside of their homes, families, and communities, and especially in regards to substance abuse, did not benefit from prevention services in the form of least disruptive measures or other prevention services permitting them to remain safely in their homes, families, and communities. Now, the tribunal's reasoning in this key paragraph is based largely on the Wende report, which, as I told you earlier, was an analysis of the inadequacies of the funding model. In essence, what they said in paragraph 245 is that Canada's discriminatory underfunding caused the unnecessary apprehension of children because of poverty, inadequate housing, neglect, or substance abuse. Now, with the greatest respect to the tribunal, that apprehensions and the statement itself misstates the evidence the tribunal relied on. The difficult decisions to apprehend any child, any First Nations child, are made by representatives of provincial or First Nations agencies according to provincial legislation. Children are apprehended for their own safety. Two most common reasons are neglect and abuse. Paragraph 245, the tribunal suggests that a First Nation agency would apprehend a child, for example, because of poverty. The evidence is reproduced in their judgment earlier on. Let's go back to paragraph 163. Our position is they quote from Wende accurately and then misuse it. So at 163, the long inserted paragraph there is a quotation from the report. What it says is secondary analysis of the Aboriginal data in CIS 98 revealed that although Aboriginal children were less likely to be reported to child welfare authorities for physical or sexual violence, they were twice as likely to experience neglect. When researchers unpack neglect by controlling for various caregiver functioning and demographic factors, they determined that the key drivers of neglect for First Nations children were poverty, poor housing, and substance abuse. It's important to note that two of these three factors are arguably outside of the domain of parental influence, poverty and poor housing. As they are outside of the locus of control of parents, it's unlikely that parents will be able to redress these risks in the absence of social investments targeted to poverty reduction and housing improvement. The limited ability for parents to influence the risk factors can mean that their children are more likely to stay in care for prolonged periods of time. This is particularly a concern in regions where statutory limits on the length of time a child is being put in care are being introduced. Parents alone cannot influence the risk, and there are inadequate social investments to reduce the risk. Children can be removed permanently. The third factor, substance abuse, for change, but requires access to services. Overall, CIS 98 results suggest that targeted and sustained investments in neglect-focused services that specifically consider substance misuse, poverty, and poor housing would likely have a positive impact on the safety and well-being of these children. So what the research actually says is that children are apprehended because of neglect. What the same research tells us is about neglect is that the key drivers of neglect are poverty, inadequate housing, and substance abuse, and that if there was more spending on the drivers of neglect, it would likely have a positive impact. What paragraph 245 does in our submission is misstate that research, brand all apprehensions for neglect as unnecessary, and draw a straight line between Canada's underfunding of child welfare services and the need for apprehension. All apprehensions other than for abuse are unnecessary, according to the tribunal, and all children and parents get the statutory maximum in compensation. Now, Canada does not deny that it must bear its responsibility for these removals and for the unacceptably high rate of apprehensions. Canada is willing to pay reasonable compensation, but the tribunal's misstatement of the research it relies on and quotes, and its ignoring of the on-ground reality of apprehension, where discretionary decisions are made by others, is designed in our submission to make a complex problem look easy, to justify maximum compensation for every child and parent, to characterize Canada's actions as willful and reckless, as if all cases are the worst case, and Canada's underfunding of child welfare is the cause of every apprehension. Neither the chain of reasoning used here nor the outcome are reasonable. Our submission there quite clearly unreasonable. To take research aimed at informing systemic reform of the funding model and to use it to award compensation in specific cases is to unreasonably rely on the general to answer a question that is inherently specific. It involves using general statements to fill in a very large evidentiary gap, and it completely ignores the role provincial authorities play in the decision to remove and the decision about where to provide or outside of the community. Questions of causality are critical in rendering compensation decisions. Court of Appeal has made that very clear in cases like Chopra. Now, we've given you some of these cases at tab 12. I'll take you there briefly. Tab 12 of volume 1 of our authorities. Paragraph, what we've given you from Chopra, and I'll only refer to Chopra, there's a couple of others there, but in Chopra, the facts are set out in paragraph 1, which we've reproduced for you. It's an ordinary human rights complaint by a complainant. But here's the legal proposition that comes out of the case, and it's from paragraph 37. The fact that foreseeability is not an appropriate device for limiting the losses for which a complainant may be compensated does not mean that there should be no limit on the liability for compensation. The first limit is that recognized by all members of the court in Morgan. That is, there must be a causal link between the discriminatory practice and the loss claimed. Now we say, and the Caring Society says we're mixing up apples and oranges because we rely on tort cases and cases under the CHRA are different. But we say they're not different in the sense of requiring principled reasoning and to show a chain of reasoning. Also, ignoring relevant case authority is itself another badge of unreasonableness. As well, I want to give you another case, another human rights case from the BC Court of Appeal. It's a case called Crockford. You'll find that at tab 13. Crockford, again, is a human rights case, as I say, and the importance of the passage that we've put to you, paragraph 49, is that the BC Court of Appeal set out the proposition that systemic cases and individual cases, because they're aimed at different things. That is a proposition, we say, of common sense, and it wasn't observed here by this tribunal. Now, the tribunal's answer to all of these arguments at paragraph 177 of their judgment is to say, and I'm paraphrasing here, we know the question of removal is multifaceted, but because Canada controlled the funding, it must pay the statutory maximum. So what if the child was removed as a result of multiple factors and not solely because of Canada's actions? Panel's answer to that is, while they acknowledge that child welfare issues are multifaceted and may involve the interplay of numerous underlying factors, this does not alleviate Canada's responsibility. And so Canada has to pay the statutory maximum. With respect, this answer does not begin to suffice. You can't make complex questions easy by relying on generalizations. Vavilov says that type of reasoning is unreasonable. Again, I commend to you paragraph 104 of the Vavilov judgment. The tribunal's reasoning is not an acceptable answer to difficult questions of causality, and the tribunal's approach is not an answer to difficult questions of proportionality either. The tribunal clearly understood that the statutory cap on compensation awards meant that the maximum awards are reserved for the worst cases, and that damages should be proportional to experience. What we've given you in that regard is paragraph 13 from the compensation decision. Another lengthy paragraph that I'm not going to read to you. But in essence, in that paragraph, we say the tribunal recognized the principle, but failed to observe it. Now, what the Canadian Human Rights Tribunal case law says about proportionality is also important here. This example I think I can give you in that regard is the Netrium Networks case, which you'll find parts of reproduced at tab 27. Let me take you to that briefly, because I think that is quite helpful on the point I wish to make to you about the importance of proportionality in decision-making in exercises of remedial jurisdiction. So this is from the tribunal's own case law, and what it says in this case is, in order, paragraph 71, sorry, I'll start at 70. The case law establishes that this maximum amount is awarded only in the most egregious of circumstances, where the extent of suffering warrant the full amount. Paragraph 71, in order to set a fair amount for pain and suffering, the tribunal must therefore assess, among other things, the emotional consequences, frustration, disappointment, loss of self-esteem and self-confidence, grief, emotional well-being, stress, anxiety, and sometimes even depression, suicidal thoughts, and other psychological symptoms resulting from the discriminatory practice. That type of demonstration is not necessarily easy to do. In our respectful submission, the approach in that case is a reasonable approach to proportionality. Recognize a limit has been set by Parliament, then carefully looking at the factors that might justify getting there is what a reasonable decision maker has to do. No such chain of reasoning appears in this case. A reasonable judgment ought to scale down from the maximum according to individual experience. That is the meaning of proportionality in damage awards. It is not sufficient to say that Parliament set a limit that may be inadequate for this case, so we will treat everyone as a worst case scenario. And that's what we say the tribunal did. They were clearly annoyed, I would say, that the limit was only $20,000. Paragraph 182 is one of those references, as is paragraph 13, which I briefly referred to. We say that a principled application of the proportionality principle was required here, that the tribunal understood it, they just didn't do it. They recognized that the maximum is reserved for the worst case and damages should be proportional, but they lacked the evidence to do individualized assessments, even in the most general of ways, not as in the way suggested in that decision. They lacked the ability to do it all. They had to take, in our submission, a rational approach to proportionality. What would that look like? Well, it would look like what was done in Netrium networks. To give you another example, we've given you at tab 14 in volume 1, an excerpt from the Supreme Court of Canada decision in Whitten. Much different context. It's about assessment of punitive damages. But what I commend to you about the Whitten case in general is that if you go through it, you'll see how they break down proportionality questions. They recognize the difficulty of the exercise and the importance of doing it right. So they offer about 6 different ways of looking at proportionality in a way that will result in a principled judgment. And it's a much more rigorous exercise than you will see in many judgments. And I'm not suggesting that every single judgment has to be as rigorous as what is suggested in Whitten or as is suggested in Netrium networks. I'm not suggesting that the tribunal necessarily needed to go to those lengths, but in our respectful submission, they showed no appreciation of the significance of the statutory maximum and the fact that proportionality ought to play a role. And we say that is not principled decision-making. Vavilov demands an acceptable reasoning process. The failure to deal with issues of causality and proportionality in any sensible way contributed to the unreasonableness of the outcome. I'm going to move on to my next point, Justice. This is going to be a somewhat shorter point because we've dealt with it at some length in our factum in relation to class actions. And so I don't intend to belabor the point, but one of the odd features of the orders in this case is that they read more like the negotiated settlement agreements typically found in class actions, more so than in tribunal judgments. However, they don't respect respectful negotiation, as in the Indian residential schools, very much like a settlement agreement that's been imposed by the tribunal. And the tribunal was explicit that it was inspired by the Indian residential schools common experience payment, despite the fact that it lacked evidence to determine to what extent experiences were common. Again, As with the hypotheticals I gave you at the outset of my submissions, experiences, one of the important features of the IRS settlement was that it distinguished between experiences by awarding additional compensation based on years in school. Tribunal here did not differentiate. Everyone gets the maximum regardless of experience because the ceiling is inadequate in their view. So they could not do a proper proportionality analysis. Now, class action does not necessarily demand that any given child testify. And whether evidence may be necessary on anything that may be contentious. That is a process that occurs in class actions that protects everyone's interests equally. And I just pause to note that the tribunal was certainly conscious of the fact that in this case, there is a pending class action as yet uncertified in this court. The tribunal asked for the claim, then asked the parties if they would like to vary the complaint in light of it. Years after, undoubtedly recognizing the impropriety of doing that, did not make the request. Now, the tribunal does have jurisdiction to deal with groups. Section 40, which you'll find reproduced at tab 3, does speak of complaints by groups of victims. This was not a case involving groups of victims. Again, Walden is such a case. Our case was a complaint by two entities, the AFN and the Caring Society. Neither represented any particular individual in the compensatory classes. So there was no representation for the removed child class, no representation for the parent, grandparent class, no lawyer to speak for the children with widely different experiences, obtaining supports or, and we say that makes this decision unreasonable. I want to turn now to the tribunal's award for willful and reckless compensation. Now, all of the pain and suffering compensation that was awarded here was doubled by branding Canada's conduct as willful and reckless and awarding the maximum compensation under that heading as well. That's according to section 53 sub 3, which is also at tab 3, which is a punitive provision for intentional discrimination according to the case law. Remember, again, the discrimination we are talking about in this case is discriminatory underfunding, i.e. funding provided through parliamentary process and appropriations. It's difficult to see how that can be considered willful and reckless. Not willful and reckless. The tribunal stressed that Canada knew its funding was inadequate because it had participated in studies like Wende that showed it was inadequate. But Canada did seek change. It replaced the directive identified in the complaints with a new model. There was evidence about that during the merits phase. Previous cases awarded willful and reckless compensation where there had been findings of discrimination that had been ignored, for example. And I'm going to return to the willful and reckless claim in a few minutes in the context of Jordan's principal compensation as well. We say is simply, there is no basis in precedent for what happened here in relation to willful and reckless discrimination. No principled justification for it in the tribunal judgment, and it should be set aside. Now, my next point relates to, we're at point number 6, relates to the alleged ongoing nature of the discrimination. So throughout my submissions, I've attempted to show that the compensation decision is not just unreasonable, but contains elements of procedural unfairness in the sense of denying the principle that a party must know the case to meet. Indeed, our point that the tribunal converted a case that focused on systemic discrimination at the remedial phase can be seen equally as a case involving jurisdictional error, unreasonableness, or a failure to provide procedural fairness. But one element of this decision is very clearly a matter of procedural unfairness, and that is the tribunal's decision to award compensation to the removed child class on a continuing basis, because in their view, the discrimination is ongoing. And what I mean by this is that a child who goes into care today, yesterday, or tomorrow is also entitled to the maximum award of $40,000. Parents and or caregiving grandparents are also entitled to that. Not so on Jordan's principle, where the tribunal found that the discrimination had ended. We say that at a minimum, Canada was entitled to notice that such an issue was on the table. So I've said many times in these submissions, the discrimination at the heart of this case was discriminatory underfunding. But in 2018, the tribunal ordered Canada to pay the actual costs of delivering child welfare services. Agencies submit their bills and Canada pays them. While it is true that the work on reform to the program is ongoing, the fact that we are now paying the actual costs to carry out the program makes it unreasonable, in our view, to say the underfunding is continuing. The effect of that is, even though we're paying the actual costs, all apprehensions, according to the tribunal, are still unnecessary. As well, the tribunal had ordered to report to them on the steps taken, so they knew this. Some of the measures that Canada took in relation to their outlined in paragraph 44 of our factum. I'm not going to take them there, but the tribunal knew that Canada had spent billions to rectify the problems and to pay the actual costs of service delivery. At a minimum, the tribunal ought to have given us notice that this was an issue, that Canada was at risk of an order to compensate that may be open-ended. The tribunal knew that we wanted to argue that they should be winding up these proceedings. We haven't been able to do that. They continue to extend their oversight and have 3 decisions on reserve still for over 2 years.
Mr.
With
Freire,
respect, yes.
Just to help me clarify things, the submission is that you can correct me if I'm wrong. From 2018 onwards, because of the order to pay actual costs, you're saying that the wording of continuing continuing or ongoing discriminatory practice was incorrect because of that Canada was the 2018 order?
Yes, at a minimum, that the decision has to be unreasonable in that respect, because there has been a huge change of circumstance, and that is not accounted for in any way in this decision, and that makes it unreasonable in our submission.
Thank you.
Now, with respect, the failure to give Canada notice is egregious in our view. The child taken into care today, as I say, will receive the same $40,000 as before we took all these steps. According to the tribunal, the underfunding is as discriminatory today as it was in 2016. And in our submission, there's simply no basis for such a conclusion. This, Justice, is a striking failure of procedural fairness, rendered even worse by the fact that the tribunal did pose questions to the parties in advance of the compensation argument. Tab 15, we've provided to you the list of questions from the record that the panel asked the parties to be prepared for during oral argument. The questions posed do not raise this issue, even inferentially. What they did show, to our considerable consternation, was the fact that the issue in the hearing was not going to be whether individual compensation should be ordered, but how much compensation, to whom, and how. The fact that compensation would flow is a foregone conclusion in those questions. We say at a minimum, Vavilov says that administrative decision makers, this is at paragraph 81, have to give reasons that are reasonable to affected parties. And on an issue as important as, is the meter still running, we were owed not just an explanation in the reasons, but a chance to be heard on the issue before they made that decision. Now, I am going to move on now to my final of my 7 points, which is the unreasonableness of the Jordan's Principle Award. This will take a bit of time because, with respect, you need some context for this. And at tab 16, if I can take you there, because we're going to go through this at some length, so you understand how we got to these orders in respect of Jordan's principle.
So, I've got one lingering question related to, before we move on to your point. So you've indicated that from Canada's perspective, there was a predetermined outcome, right? Compensation was going to happen. It was who to how, I think is what your words were. So you're not suggesting that the discretion in any way was fettered or anything of that nature? Just want to make sure.
No, it's not that, Justice. What I'm saying is, if you look at those questions, what they asked the parties to be prepared for was questions that certainly contemplate that compensation is going to be paid out, but it wasn't the totality of what was going to be said before them. So I'm not making that suggestion. What I'm saying is, if you're going to identify issues of importance, certainly that one ought to have been in the list.
Thank you.
Okay, so if I can take you then to tab 16, and here we start on some background to understand how we got to where we are on Jordan's principle. So Jordan's principle essentially dates from the House of Commons resolution on December 12th, 2007. And it's simply stated that in the opinion of the House, the government should immediately adopt a child first principle based on Jordan's principle to resolve jurisdictional disputes involving the care of First Nations children. Unanimous vote of the House, not binding, but that was where it began. The complainant's complaint, which we've reproduced for you at that tab, says Jordan's principle, a child first solution to resolving jurisdictional jurisdictional disputes has been developed and endorsed by over 230 individuals and organizations. Solution is cost neutral and would ensure that children's needs are met while still allowing for the resolution of the dispute. That's what they said about Jordan's principle in their complaint. In their particulars, at paragraph 13, they said that as the complainants will also demonstrate, this discriminatory practice contravenes Jordan's principle passed unanimously by the House of Commons on December 12, 2007. In the merits decision, what you find is language that is very consistent with that simple proposition from the House of Commons resolution. That sort of language continues through to pause there. If I can just pause at paragraph 481 of the merits decision, where they said the panel is generally supportive of the request for immediate relief and the methodologies for reforming the provision of child and family services to First Nations living on reserve, but also recognizes the need for balance espoused by ANDC. Canada essentially is ordered to cease its discriminatory practices and reform the FNCFS program and the 1965 agreement, that's the funding agreement between Ontario and Canada, to reflect the findings of this decision. Canada is also ordered to cease applying its narrow definition of Jordan's principle and to take measures to immediately implement the full meaning and scope of Jordan's principle. And our contention is the full meaning and scope is not revealed until 2017, because if you look at the excerpts we've given you from 2016 CHRT 10 and 2016 CHRT 16, you find language used by the tribunal consistent with the House of Commons definition. Where the evolution takes place in our respectful submission is in the judgment of the tribunal in 2017 CHRT 14. And what you find, it's in our excerpts, paragraph 135 is these words. Pursuant to the above, the panel's orders are: 1, definition of Jordan's principle. As of the date of this ruling, Canada shall cease relying upon and perpetuating definitions of Jordan's principle that are not in compliance with the panel's orders and previous decisions. As of this date of ruling, Canada's definition and application of Jordan's principle shall be based on the following key principles. 1, Jordan's principle is a child-first principle that applies equally to all First Nations children, whether resident on or off reserve. Is not limited to First Nations children with disabilities or those with discrete short-term issues creating critical needs for health and social supports or affecting their activities of daily living. Jordan's principle addresses the needs of First Nations children by ensuring there are no gaps in government services to them. It can address, for example, but is not limited to, gaps in such services as mental health, special education, dental, physical therapy, speech therapy, medical equipment, physiotherapy. 3, when a government service is available to all other children, the government Department of First Contact will pay for the service to a First Nations child without engaging in case conferring, policy review, service navigation, or any other similar administrative procedure before funding is provided. Once the service is provided, the government Department of First Contact can seek reimbursement from another government department or government. 4, when a government service is not necessarily available to all other children or is beyond the normative standard of care, the government Department of First Contact will still evaluate the individual needs of the child to determine if the requested service should be provided to ensure substantive equality in the provision of services to the child to ensure culturally appropriate services to the child and or to safeguard the best interests of the child. And I want to pause there because this becomes, from this date, the recognized definition of Jordan's principle. And what I would say to you about that definition is make no mistake. A great deal of distance has been traveled between the 2007 definition of the House of Commons and the 2017 decision. The government did not seek review, as the tribunal and our friends have been quick to point out. The result has been a very large number of First Nations children have benefited greatly. I point this out to you not to be critical, because the government remains firmly committed to Jordan's principle, but to recognize that this is systemic reform in action. The government accepted that it was a necessary systemic reform. Neither of these judicial reviews before you are about trying to roll back Jordan's principle. We certainly object to the gloss put on Jordan's principle for the purposes of expanding compensation in the definitions decision, and I'll be addressing the other difficulties with the First Nations child decision on the second application later this week. But we don't think that our argument is fairly characterized as trying to roll back Jordan's principle, because that is not what we're doing. Is saying that when it comes to compensation, it has to be underscored that the full flowering of the definition did not occur until 2017. And I pause there to say, although the definition did seem to be complete in 2017, it was subject to expansion twice more in 2020. First through the definitions decision, and then by the First Nations child decision. Again, we're not seeking to roll it back. The fact that we accepted the 2017 decision as a remedy for systemic discrimination does not prevent us from challenging the award of compensation retroactively for the tribunal's evolving conception of Jordan's principle. Now, I wanted to now to talk about the definitions decision, the whole of which is set out at tab 2 of volume 2 of our condensed book. And maybe we can start there. No, we'll start. I want to take you back to the order, because this case really is about the order. So if we can go to back to the tribunal's decision at paragraph 250.
So you're talking about the merits decision?
No, I'm not talking about the merits decision. I'm talking about the compensation decision,
okay,
which is at tab 1 of volume 2.
And you're back in the orders, okay. I follow.
Okay, so yeah, and I referred you to this briefly before, and again, it's a long thing. But the first sentence is really the one that matters for the purposes of determining compensation and leads directly to the definitions decision. So paragraph 250, the panel finds that there is sufficient evidence and other information in this case to establish on a balance of probabilities that Canada's systemic racial discrimination found in the tribunal's merits decision and subsequent rulings resulted in harming First Nations children living on reserve or off reserve who, as a result of a gap delay and or denial of were deprived of essential services and placed in care outside of their homes, families, and communities in order to receive those services, or without being placed in out-of-home care, were denied services and therefore did not benefit from services covered under Jordan's principle as defined in 2017 CHRT 17 and 35. For example, mental health, suicide prevention services, special educations, dental, etc. So the difficulty, you'll recall that after we argued the stay motion, we went back to the table to fashion a compensation framework. In the course of doing that, there were a few times where we simply couldn't agree on things, and it had to go back to the tribunal to get further guidance. So the definitions decision is one of those instances. It arises because in paragraph 250, they've used three terms that we couldn't agree on common meaning of. The three terms were essential services, service gap, and unreasonable delay. Those terms are not defined in the compensation decisions. So now what I want to do is walk you through what the tribunal did in relation to those definitions. And to do that, I want to take you to tab 28 of our volume 1 of our condensed book. So the parties got to make submissions to the tribunal on these terms. And for the purposes of Canada's submissions, we relied heavily on a paragraph from the compensation decision. And that is paragraph 226 that you'll find reproduced at tab 28. And what the tribunal had said in the compensation decision is that First Nations children are denied essential services. The tribunal heard extensive evidence that demonstrates that First Nations children were denied essential services after a significant and detrimental delay, causing real harm to those children and their parents or grandparents caring for them. Now, again, we say this is the tribunal saying there was a lot of evidence that we say didn't exist. But the importance of that to us in trying to give meaning to these terms was the fact that what the tribunal was wanting to compensate position from their judgment. So on essential service, what we asked the tribunal to consider was, for the purposes of compensation, there had to be a request to the federal government for a supporter service, and that the supporter service had to be necessary for the safety and security of the child, the interruption of which would adversely affect the child's ability to thrive, the child's health, or the child's personal safety. We accepted that the principles of substantive equality and best interest of the child should be considered. In our submission, that sort of definition is necessary to be consistent with a judgment that said there has to be real harm. To compensate someone, especially if you're going to give the maximum, there has to be real harm. Tribunal's response was first to deny our request that a child or someone on behalf of the child had to make a request Essentially what the tribunal said, accepting the submissions of my friends, was that to require that a request for services had been made would be unfair, because Canada's conduct had deterred people from making requests. Because people knew Canada's definition was so narrow, they wouldn't even have made requests. But it leads to a situation where compensation is given without a request having been made. The panel also rejected our second submission, but and I'm not going to read all of this to you, but because it's kind of difficult, frankly. The tribunal rejects our definition, but agrees with Canada that some measure of reasonableness ought to govern, and then left it to the parties to define what that would be. On unreasonable delay, what Canada suggested to the tribunal was that unreasonable delay should be informed by the nature of the product, support, or service sought, because that seemed to us an obvious factor. The reason for the delay, the potential of the delay to adversely affect the child's needs, and the normative ranges for providing the category or mode of service or services across Canada by provinces and territories. Now, let me just pause there. What we were asking the tribunal to do was say an unreasonable delay should be assessed against normative standards, i.e., how long does it usually take other Canadians to get these same supports or services? Because if First Nations children are waiting longer, that certainly looks discriminatory. So assessing against normative stand to us to be an obvious way of making sure that the order would be reasonable. It was rejected by the tribunal. As well, if we go to service gaps, our position on service gaps was with respect that there should be a dispute between jurisdictions or departments as to who should pay, going back to the original meaning of Jordan's principle, because that leaves a gap. The child is unserved because governments are squabbling. That seems to be something that should inform compensation, rejected by the tribunal. We also asked, would normally have been publicly funded for any child in Canada? Again, if a First Nations child is not getting something that other children are getting, that is discrimination. We suggested that that was a reasonable standard against which to measure discrimination. Tribunal said not so much. Now, in our respectful submission, what the definitions decision leads to is something that is unreasonable. There is a failure to impose limits based on principles that ought to have informed decision-making, so that a decision to compensate was a reasonable one. it would realize that a denial that had no adverse impact was not compensable. The tribunal in this decision painted with the broadest of brushes. For the tribunal, again, every case is the worst case for both First Nations kids and their parents. There is no evidence to justify this. No logic justifies that, but giving them magically makes the evidentiary problem go away. Canada went back and looked at denials after the tribunal's judgment on the definition in order to give kids who were denied supports and services before the 2017 definition came into effect, to see whether to assess their requests against that new standard. In our respectful submission, that is a responsive remedy to what the tribunal was doing in the way of systemic reform. The result of this definitions decision here is that the maximum compensation is payable where no request was made, no adverse impact was experienced, and any delay did not exceed provincial standards. Both parents or caregiving grandparents will also get the same maximum amount. To award $40,000 to each of those children and their caregivers is bound to be vastly disproportionate to the harm suffered in many cases. Presumes that every child experienced delay also experienced pain and suffering. This result, in our respectful submission, is manifestly unreasonable. And how can the determination of willful and reckless discrimination possibly be justified? Canada could not intuit the evolution of Jordan's principle. When we accepted the tribunal's decision in 2017, we were said to be in full compliance by the tribunal. There is no basis at all for a finding of willful and reckless discrimination in these circumstances. The tribunal's approach to compensation under Jordan's principle is simply riddled with unreasonableness, and it should be set aside. Now, I'm coming to the end. I see it's 12:30, but I have maybe 10 more minutes and I will be finished. If you want to keep going, that probably is best for my friends in response.
Sure. Yes, Mr. Prater, if you feel comfortable continuing, I'll defer to you.
Okay. Thank you, Justice. So it's obvious from what I've said this morning that the applicant requests that this decision be set aside in its entirety. This was not a case for individual compensation. We accept that harm is provable, but it was not proven here. It did not have to be, because it was not in the nature of the complaint as framed by the complainants. Now, in the alternative, obviously, it's open to you to conclude that only some aspects of the compensation decision are unreasonable without setting aside the decision as a whole. So in our submission, some seem so devoid of reason, like the award to the grandparent class, the broad sweep of the Jordan's Principle Award, the willful and reckless finding, the continuing discrimination finding. Those are very difficult parts of this decision to uphold. And we ask as well, if Justice, you're of a mind to return this to the tribunal with directions, and we accept that Vavilov says that's appropriate in many cases, but it's not appropriate in all cases. There is an exception, and that is when it would serve no purpose. And in our respectful submission, we're in the exceptional situation here. because there is no point sending it back to the tribunal when the tribunal lacked the evidence to make the findings that it did. So in our respectful submission, the appropriate order here is simply to set aside the impugned decision as a whole. Alternatively, you should look at the various components of it and decide whether some or all of them should be set aside as unreasonable. And if you do order it to be returned to the tribunal, we are asking you to send it to a different panel. With respect, the decision here is so deeply problematic. The process that was adopted is unacceptable. It would be better to start again with another tribunal on this discrete issue. So those, with respect, are my submissions on the order that we're seeking. And subject to any questions from you, Justice, those are Canada's submissions on the first application.
Thank you, Mr. Frater. The only additional question that I'll pose is based on, as you know, the submissions of the respondents. I think, if not all, most of them, if not all, refer to this as a collateral attack on the merits decision. And you know, just looking at the merits decision, the paragraphs 489 in particular also talk about what you've submitted here, that there's insufficient evidence to award compensation. Although, you know, that was a different point in time. It wasn't the actual order here. I appreciate that. And that there was an absence of individual evidence. So I'd like to hear, before we break, what your position is in reply to those arguments of your friends.
Yes. Well, we say this is not a collateral attack on the merits decision or any of the subsequent decisions. The merits decision and the subsequent ones before this one were all targeting systemic reform. Canada accepted the merits decision as stating that we had to reform the system. And so there was no judicial review. Similarly, as long as the tribunal was confining itself to decisions in relation to systemic reform, we did not judicially review them because, in our view, that the systemic reform was ongoing, and we accepted that. When they changed the nature of the case from something that was different from the complaint as framed by the complainants, then we came to this court. And that's why we're here today. It's the changing of the nature of the case, and it is we can challenge that decision without collaterally attacking the merits decision or any of the others.
Okay, thank you for your submissions. Just looking at our schedule or our general timetable. For day one, it was indicated that Mr. Frater would submit approximately for 3.5 hours and the Caring Society for half an hour. Are you your submissions in chief? Are you completed for your 3.5?
Oops. Yes, I'm not planning to use my entire time. You have our factum. There are other things in the factum you can look at, but I've said my piece.
Okay. Well, in that case, just to make sure that we thank you for the answer. Just to make sure that we fully recharge, and I note that the Caring Society has 30 minutes for day one. I'll propose that we reconvene for in just over an hour, so 1 hour and 20 minutes, just to give everybody a chance to refresh and rest. So that will be 2 o'clock Eastern time. Is that acceptable to council?
That's fine with Canada.
Let's do a little roundtable, if that's okay, council.
Good afternoon, Your Honor. For the Caring Society, that's acceptable. I can advise the court if it's assistive. I can go for more than 30 minutes this afternoon. I am ready, but I probably won't finish this afternoon. As Mr. Frater has raised a lot of interesting points that we'll definitely want to address this afternoon. But, you know, in fairness to the court and making sure we use the time appropriately, I'm happy to go beyond 30 minutes if the court's agreeable, but also happy to just use my 30 minutes this afternoon, whatever best for the court.
Thank you. Yeah, I noticed that for day 2, we're looking at approximately 2.5 hours, so a total of 3 hours for the Caring Society. So, you know, if you're prepared to go for an hour or an hour and a half once we reconvene, I think we can adjust our schedule accordingly for the remaining days if that works for people. All right, so so I was proposing 2 p.m. Eastern that we would reconvene. Works for people?
That works for the Assembly First Nations.
Thank you.
That's fine for the commission as well. Thank you.
Thank you.
It's fine for the Caring Society. Thank you.
Perfect.
Fine for Nan. Thank you.
I think we've got everybody. All right. Thank you both. Thank you everyone for agreeing to that, and we'll reconvene at 2 p.m. Eastern. Thank you.
Well noted. The court is now in recess for lunch break.